Welcome to Solving Citizen Legal Encounters. All right, today we're going back into the Nevada court where we're dealing with the sovereign citizen that we've been following for a while. Also, I want to give a shout out to our Nevada judges. I got a link in the description. You can just check out and see what they do on their channel. Now, we're going to go in because this is a status check hearing, and we're going to see how things go. You never know what surprise you might hear in this hearing. Let's go.
Austin, are you present?
Yes, I am present.
Okay. I just wanted to make sure that you were aware that we were going forward. So where we're at, currently this was on for a status check in order to ensure that the state had found a Gab Millennium expert. I did see that a notice was filed by the state yesterday with I'm not sure if it was yesterday or the day before, or over the weekend. Friday, maybe
last Thursday.
It was last Thursday. Okay. The notice was filed though, that with a copy of the CV. There is also Ms. Zhang has filed a motion to disqualify the district court. That is currently set for March the 13th. I would note that Ms. Zhang also filed something over the weekend in order. It was a due notice with additional information in it for Chief Weiss. And I would just want, and I believe that Mr. Sachs filed a joinder to the motion to disqualify as well. I don't know if Mr. Goodwin, if you're aware of that. However, again, under 8th Judicial District Court rules, it is improper, Mr. Shetler and Mr. Goodwin, for your clients to be filing anything when they are represented by counsel.
Now that's a shame because they're getting in trouble for their clients doing things behind their back. And in the last video I put up, I had the question of how long will these attorneys last? And if things keep happening where motions are being filed behind their backs, eventually they're going to probably withdraw from the case. But as we're following it, we'll find all of that out. Let's go back in.
So what do we need to do to address this?
I filed the joinder, Your Honor.
Okay. Okay, so Mr. Shetler, what do we need to address this?
Your Honor, I did not file anything on behalf of Ms. Zhang. I know our co-defendant, I believe, filed a document, and I know the court has addressed this previously. I am open to suggestions as to the best way to address it, Your Honor.
All right, she's not here, so I'm going to leave it up to you, Mr. Shetler, to admonish your client that she is not, while represented by you, to be filing anything. If she wants to have something filed, she needs to get in touch with you and she needs to have you file it, or at the very least, if you agree with the filing that she has filed, then you need to file something that indicates that you are adopting it as a filing that you would have made on your client's behalf. I'm perfectly willing, which is the same thing that I said to Mr. Goodwin when his client filed his lengthy affidavit the last time, that I was perfectly fine with, okay, they weren't able to get in touch with you, things happen, but in the future, just file something that says that if you would have been provided with something of this nature, that you would have adopted it and filed it on your client's behalf. I'm okay with that.
I'm sorry, I do understand that, Your Honor. You did make that clear last time. I'll follow up on it. I think that's all the information I have right now.
All right. So to the extent that the court was served with the motion to disqualify and filed an affidavit, there was an additional notice and it seemed to be disputing some of the things that the court said in the affidavit. I will leave that up to the chief to decide. I will note, just for purposes of the record, that some of these allegations that are being made were the subject of a prior motion to disqualify that has already been addressed previously by the chief. And then the parties filed a motion to disqualify the chief, to which Judge Denton decided that went up to the Supreme Court. So to the extent that there are new allegations, that's fine, but to the extent they've already been dealt with, I don't know if it's proper to be re-bringing them up again, which is why I'm just gonna make a notation that to the extent that there's been a new notice filed, Mr. Shetler, that seems to have additional allegations in it. This court is not going to address those allegations because it believes that it was improper for Ms. Zhang to file an additional notice after she's already filed a supplemental affidavit. And I'm also not going to address the supplemental affidavit because the supplemental affidavit seems to be dealing with allegations that were from prior motions to disqualify, and in any event, there isn't anything within the rules, I don't believe, that allowed for a supplemental affidavit to be filed after the original affidavit is filed, because arguably we'd be going back and forth ad nauseum forever if that were the case.
I remember the judge saying in a previous hearing that once they accepted the attorneys, they had to work with them. But it seemed like they really don't because they're still following their own motions. So it may be best to just let them go back to doing their own thing and then seeing how things turn out. But also they may want the attorneys in there to try to speed these hearings up because it's been going on for so long.
So, I'm not going to strike either one of the documents. I believe that this record that the court has made is sufficient. But I'm just gonna note those for purposes of the record as to whether or not there's ever a question as to why I didn't address the supplemental affidavit. There's a record that's now saying the reason why I'm not addressing the supplemental affidavit. That being said, I was going to simply set this for a status check because obviously under the rules, the court can't take any action. And if the motion to disqualify were granted, obviously it would be because we're going to reset the trial. The court was simply going to find out how long Ms. Renetti was going to need for that expert report to be provided to counsel. And then if you all were going to need additional time from your expert to do any sort of rebuttal report or any sort of argument, and then we were going to reset the trial based on that. To the extent that at this juncture, the court doesn't know whether or not it's going to have the case, it would be improper for me to set the trial at this juncture. So I was simply going to set a status check for after the motion to disqualify was addressed. So I don't know whether or not it's going to be decided on by minute order, if it's going to be decided by virtue of an actual hearing, but it's set currently for hearing on March the 13th. So I was going to give, in case it wasn't decided at that actual hearing and Judge Chief Weiss needed some additional time, I was going to set it for 2 weeks after that hearing to kind of see where we're at and see whether or not he had made a decision at that juncture.
Sure.
Does that make sense to everybody, or would anybody like a different resolution at this time? Okay.
Makes sense to Shetler, Your Honor.
Renetti, does that work for the state?
Yeah, I believe the court can't do anything until that motion is heard and ruled upon, so I appreciate the court setting a status check.
All right, so let's go ahead and set it for that first week in April.
April 2nd at 9:30.
Thank you, Your Honor.
Thank you.
All right, we're moving along through this case. And actually, I have 4 for you today. So the next hearing that she mentioned, we're getting ready to watch that hearing now. Now, she said April the 2nd, but I have it listed as April the 3rd. It could be wrong. But we're going to go in and see what this hearing is about and see what changes come up. Let's go.
Mr. Shetler, are you there?
I am, Your Honor. Can you hear me okay?
I can. I don't have Miss Renetti here. And I don't have,
It's gonna be somebody else covering their next door.
okay.
Mr. Fennell is covering Ms. Renetti.
Okay, so Miss Renetti's, or somebody's covering for Miss Renetti, they're next door right now, so if you'll just hold on. I know that there was another motion for reconsideration that was filed. I believe that it's now been placed with Judge Weiss because it was a motion for reconsideration. It was set on my calendar. But we reached out to the Weiss or to the Chief Weiss, because obviously it's a motion for reconsideration on a motion to disqualify. So we reached out to him to let him know that it needed to be put on his calendar. So until such time as that is taken care of, there's really no point in me doing anything. But I did want to make a quick record once I have, somebody from Miss Renetti over here.
He actually just. Oh, there he is. Now he's up.
I love when I'm talking to myself. Sorry, Mr. Shetler, you disappeared there for a second and then we got you back. So I was just saying that obviously, they had set the motion for reconsideration on the motion to disqualify on my calendar. We reached out to the chief because obviously that's something that needs to be heard by him since he did the original motion to disqualify. But I was going to make a quick record once the person that was covering for Miss Renetti shows up. So if you'll just hold on for us, okay?
I will. Thank you, Judge.
Thank you. There he is.
Yes, Your Honor.
Good morning. All right, so this was the date and time set for the status check as to the expert reports being done and make sure that we were on the same page. I kept it on calendar because I'm really not making any decisions today. It was simply a status check. I wanted to let both sides know the motion to reconsider the motion to disqualify was originally set in this department and has now been set for April the 24th in front of Chief Weiss. So he might come out with a decision prior to that, but we're on calendar still for September trial date. I just wanted to make sure that we are still on track for that, assuming that the court is not that I'm not disqualified from the case.
From the state side, in all candor, Miss Renetti was sick today.
Okay.
So I don't know if the court was waiting on any experts on her side. I know with her
Yes.
cases, obviously.
Yes.
So unfortunately, I just don't have any details today.
Okay.
Specifically. I apologize.
Okay.
If Mr. Shetler's okay with it, if we want to push it out a few weeks and she'll be able to follow up with Mr. Shetler. He's very easy to get a hold of and speak to. So I think they can figure it out.
That's fine. And I will just note for purposes of the record, Mr. Shetler, I note that, you had refiled Mr. Sachs's affidavit into Miss Zhang's case from the last hearing, making sure that that was something that the chief saw. I will just say this. I believe he did simply because of the fact that I had seen it. And so I actually addressed it. I want to say this because it was maybe not clear to your client or Mr. Goodwin's client. So for purposes of the record, I worked as a med mal attorney. He's utilizing my candidate speech that I did for independent Black voters back when I was talking. That was back in Michigan over 20 years ago.
You're talking about going the extra mile.
At this point. So to the extent that I represented hospitals back in the day, we created a record retention policy. And I think I had one case where I represented a doctor from the ER room. Other than that, that was all I did. All of my firm was known for being a med mal firm, but I was on the asbestos litigation track, and really didn't handle a lot of the medical malpractice or work for hospitals other than that record retention program that we came up with, which was a copyrighted program. And it's 24 years ago at this point. So that was when I first got out of law school, 2001. We're in 2025. So yeah, 24 years ago. I was there for 4 years. So you want to say 20 years was my last date of doing that. So to the extent that there was concerns about that I wouldn't be impartial or that I would be biased towards the physicians and the doctors, I'm not making the decision on this case. This is a jury trial and it's up to the jury. Second, I wanted to point out that to the extent that I addressed it in my affidavit, but it wasn't clear, I'm aware of the fact that that video that he posted on YouTube that says brazen violations or whatever, that's his opinion. That is not a fact. And that was my whole point of saying, yes, I'm aware that there are JAVS transcripts that have been posted or JAVS videos that have been posted on YouTube, but that's his opinion. He's entitled to his opinion, and it doesn't affect, everybody's entitled to their opinion. Everybody has First Amendment rights. Doesn't affect my ability because that's his opinion. He's had that opinion about 5 other judges, 3 Supreme Court justices, and 3 other Supreme Court justices, as well as the 2 prosecutors in this case. So consider the source on that one. So I have no bias. I'm going to be fair. I'm going to be impartial. And I just wanted to address those 2 points because it seems to keep coming up in the affidavits. And so I wanted to make a record of that because I was not personally served with this motion for reconsideration. So I did not do an affidavit because I thought that I had adequately addressed it when I did the last affidavit. And so to the extent that either your client, Mr. Shetler, or Mr. Goodwin's client believed that the court was agreeing to the allegations in this new affidavit because I didn't address it, I believe that those allegations were sufficiently addressed by my last affidavit, which is why I didn't file a new affidavit. So just wanted to make a record of that.
Sounds good, Your Honor.
I understand procedurally. That makes sense, Judge.
All right, so let's, since it's set for the 24th, it might be heard before that, might do a minute order. Let's set it for the week after that 24th so that we can just make sure that everybody is on track and experts are online and we're on track to go forward with trial.
Sounds good.
So it's gonna be April 30th at 9:30.
Thank you, Your Honor.
Thank you.
Appreciate it.
Your Honor, one other matter. Did we get to the point where we pinned down a date in September yet, or we're just kind of holding September?
I think we're just holding September right now.
I understand.
Yeah, so, but we can discuss that when we come back on the 30th.
Thank you, Judge.
All right, thank you.
All right, you see there's a lot of things that's being discussed, basically like another status hearing and things that's going on with these motions and the research and all of this stuff that's going on. But the main thing is that they need to get that case done. So now we're going to go into the next hearing and see how that hearing unfolds. Let's go.
State of Nevada versus Yuxia Zhang, case number C343540.
Raising bits for the state.
I Judge Shetler, 2747.
Hi. So this is on for a motion to withdraw as counsel.
I knew this day would come.
Ms. Zhang, are you there?
Yes, I'm here.
Okay. Based on the affidavit that I saw, it says it appears as if Ms. Zhang has requested you to not be on the case, but I didn't have anything from her that said that she had actually fired you, and she has invoked her right to have counsel, and we have nobody left. So I don't feel comfortable granting this motion. We've reached out to the special prosecutor's office. Mr. Shetler was it. And so to the extent that you would want counsel, I have nobody else within the state that I can appoint for you.
Why not?
Because you've gone through every single attorney.
Oh, we definitely know of an old timer that was doing this for a long time. You know who it is.
Sorry, I don't catch. What's that meaning?
It means that the state has only a certain number of attorneys that are either public defenders or work through the special prosecutor's office. And you've gone through all of them. We have nobody else that we can appoint for you. So I'm not going to allow Mr. Shetler to withdraw.
This is a violation of my process rights.
Eh?
Ma'am, no, it's not. because you have been appointed attorney after attorney after attorney, and you are not listening to your attorneys. And I don't have anybody else that I can appoint for you.
It's not, I don't listen my attorneys. My attorney don't listen me.
So we all know if they're not talking the same legal language that the attorney is talking, they're going to withdraw from the case because they don't want to get caught up in some type of frivolous thing with the judge.
Well, I don't have anybody else that I can appoint for you. So
I can recommend myself.
if you can get your own attorney, great. You can get your own attorney and you can have them substitute in for Mr. Shetler. But no, you asked for this court to appoint you an attorney. You said that you couldn't go forward without an attorney. Yes, you had a phoretic canvas before and you passed your phoretic canvas, but then right prior to trial, you and your husband said that you could not go forward without an attorney. So the court went through great effort and great expense to make sure that you had an attorney to represent you. And now I don't have an affidavit that says that you've fired him. I don't have anything that indicates that Mr. Shetler is not doing a good job. As a matter of fact, he's done a very good job for you. And
Okay.
I'm not going to allow him to withdraw at this time unless I have more information, because the only thing that the court currently has is that you all disagree on where you would like this case to go. But you've disagreed with every single one of your attorneys, ma'am, and we have delayed this trial. Let me finish, and then I will let you speak. And we have delayed this trial over and over and over and over again in order for you to be able to either have representation or go forward on your own or get expert witnesses. And we're not going to keep on delaying the trial. And as it currently stands, there are no other attorneys within the state of Nevada that I can have appointed to this case. You've gone through them all.
Okay.
Now
Okay. Now it's my turn, okay?
Yes.
Okay, I need to make a record and have a right to be heard. I, Isha Zhang, understand that I am to tell the truth in all matters. And if I do not, I'm subject to the penalties of perjury. Having qualified my testimony, I aver that Ms. Shelter has been in effective assistance of counsel for around 6 months. He repeatedly failed to take an active role in my defense, and he failed to file several important court documents at my request. In addition to that, he ignored my multiple emails regarding the urgency to file those same court documents. As Ms. Shelter refused to respond, he left me no choice but to file those court documents on my own, which has been termed by the court as fugitive documents.
So she just read basically what I've been saying. The attorneys are not going to file anything into the court that doesn't meet the state law. That's where their conflict is going to remain until something gets figured out in this case.
They would not have been fugitive if Ms. Shelter has simply and timely filed them. Ms. Shelter admits to a breakdown in communication in his April 18, 2025 motion. I would go so far as to say there is no attorney-client relationship here, as my emails go ignored for long periods of time and important deadlines are missed. For example, in Ms. Shelter's February 21st, 2025 letter to me, he wrote, "You are entitled to timely response."
Hold on 1 second, Miss Zhang. Let me stop you for 1 second. I don't want to hear this because I want to admonish you for 1 second. Anything that you share with the court that is between you and Mr. Shetler is attorney-client privileged. So if you are going to read anything between you, I need you to understand that you are waiving that attorney-client privilege at this juncture. Do you understand that?
Yes, I will.
All right. Go
Okay.
ahead.
Ms. Shelter goes on to state in his April 18, 2025 motion, the basis for the request is that the undersigned and Ms. John are unable to agree on defense strategies. I completely agree, and for this reason alone, Ms. Shelter must be replaced. There is no making amends or opportunities for reconciliation here. There are numbers of loose ends for my defense that still has not been addressed by Ms. Shelter in all these months after repeated attempts to take action. This is akin to having Ms. Shelter pull my life raft under the water. This is an unreasonable and intolerable situation. Lastly, I do not trust I would get a fair trial with Ms. Shelter as my court appointed counsel and respectfully require this court to substitute replacement counsel as soon as possible. I stand on my statement here. Thank you.
Thank you. Mr. Shetler, I'll hear from you.
I don't know if there's much to add, Your Honor. We certainly, when I came onto this case, I certainly did not expect that every day was gonna be, laid back and relaxed. And, I have, without getting into any other issues, made several efforts to try and facilitate communication. Frequently, mostly my communication is with, the co-defendant. They'll do a conference call, which generally that's fine. His attorney is aware of it. I'm worried if I actually get information from my client at times, but there's certainly no question that we are at a challenging place communicating with each other. We do have a difference of opinion as to whether or not some things will be helpful or not helpful. My goal is to get her to a not guilty verdict or as best as I can. And I think I can do that. I didn't file that motion lightly. I don't want to say much more. I just think that I'm happy to stay on the case. I fully expected this would probably be the outcome. To remove me at this time would only delay things further if there was someone to replace me with.
There's not.
My client may file some more paper. I don't know. I'll stop there.
I don't have any information in front of me as to what you failed to file. And everything that I have seen, I understand that originally they were treated as fugitive documents, but subsequently you filed them. They've been considered, and I'm speaking specifically to the motion to disqualify me, the affidavits that were filed. All of that has been addressed by the chief. There was a motion for reconsideration that was filed. That was addressed. All of those have been addressed. I don't know what other filings that potentially she wanted you to file that have not been filed. I will say for purposes of the record that you have a duty as an officer of the court to not file anything that would be frivolous or vexatious or harassing. You also have a duty under Rule 11 to make sure that anything that you file is either supported factually or supported by the law or for a good faith extension or modification of the law. And so I have not been provided with any additional information that would show that you have violated that duty as far as not filing something that she had asked you to file that was in fact either not frivolous or backed by existing law and or a good faith extension modification of existing law and or factually supportable. So if there are documents that she has asked you to file that would fall within those parameters, i.e. they are factually supportable, or they are backed by existing law and or a good faith modification or extension of existing law, and those have not been filed, then the court would entertain potentially a motion with additional information. But right now, based on what has currently been provided to the court and based on the posture that this case is in, and we did reach out to the special prosecutor's office, we reached out to Susan Bush, there is nobody else that I can appoint at this juncture. And so the court is left in between a rock and a hard place of, we've gone through all of the attorneys that could be appointed in this case. And when you were appointed, it was based on Ms. Zhang's very specific request to have counsel, not standby counsel, but actual counsel appointed for her. And so we did that, and there's nobody else that I can appoint at this juncture. And so without an underlying factual basis that is sufficient to allow the court to allow you to withdraw, I am not going to grant the motion at this time. You are instructed to stay on the case and to attempt to work with Ms. Zhang to try and bridge any gaps that you all have. Thank you.
Object, I object.
Your objection is noted for the record, Ms. Zhang. Thank you very much.
Object.
Noted for the record. Thank you very much. We're off the record.
Now that hearing was a little intense, had a little bit of heat to it. And I know the attorney is saying that he will stay on the case and try to help out because that's what they normally say. But maybe in his mind, he is probably done with all of this because he knows it's just going to be a back and forth battle. She doesn't want to listen to what he has to say, and he's trying to get her through the case. And it's always going to be this argument. So we'll see what's going to happen. We have one more hearing to check out. So let's go in. Let's go.
All right. I want to start with, since we were here on Monday, Mr. Shetler, have you had an opportunity to talk with Ms. Zhang? Has that relationship been at least repaired, or where are we at?
To my knowledge, I think we're moving forward, Judge. I did receive an email and explained that we were with specific directives in it, and I'll go through those and get back. So I think we can move forward.
All right. I just want to make a representation on the record. We did speak with Susan Bush today. On Monday, when I made the representations that I did, we had reached out, had not heard back, but I had at the very last hearing told, or when you were appointed, Mr. Shetler had said that basically we had gotten the last of the attorneys that we were going to be able to get. In speaking with Ms. Bush, I was in fact told that if in the event that the relationship was irreparably couldn't go forward, that I could, in fact, we would be able to, in fact, find another attorney, but it would not be an attorney that would have the same sort of attorney-client relationship. It would just be an attorney that would come in and try the case. So I wanted to let you know that if it does get to the point where it just obviously cannot go forward, then I will, we can get somebody, but it's not going to be the same sort of person that they're going to be able to email and have filings done. It would just be somebody that would come in and try the case.
Well, that's definitely a new angle I never heard about. I wonder if she's going to take the judge up on that offer if things don't work out.
I will pass that on to my client after the hearing, Your Honor. If I hear something that she would like that, then I'll make sure and bring it to the court's attention.
All right. So we are here today to reset the trial date on this. I couldn't do it the last time because there was a pending motion to disqualify and then the motion for reconsideration. That motion for reconsideration was addressed and an order entered that was denied. So I am staying on the case and everybody's staying on the case and we just need to move forward with this. So where are we currently at as far as setting the trial dates on this?
Your Honor, I know that, and I'll certainly let Charles make his own representation. I know that his clients directed him to get the earliest trial date possible. My clients directed me of the same. We did speak a little bit, Ms. Renetti and I, about what is available on our calendars. It seems, if I'm correct, that the court's first available date would be after September 15th or September 15th itself.
That's correct.
We were able to talk, that does work with our calendars. I know that's longer than my client wants. I'm sure it's longer than what Charles' client wants, Mr. Goodman, but that's what I know, Judge.
Okay. Mr. Goodwin?
Yes, Your Honor, I would just like to object to this going further. If there is an available stack before the September date, we would be requesting that date.
I don't believe that there, I mean, I could conceivably,
Maybe to help, Charles, we're still looking at about a 3.5 week setting, correct?
That's correct, Your Honor. And that's based on, I believe, Ms. Renetti's understanding of her witnesses. I predict that our witness might take half the day. I don't know how long Ms. Renetti's intending to cross.
The beginning.
yeah, I have beginning of August into October, but I mean, I could give you guys beginning of August, but that's the best I would be able to do.
And unfortunately, I have a personal commitment I can't get out of the beginning of August that I need to handle in the beginning of August. So we could do that September 15th date. That would avoid any Labor Day weekend with doctors and other witnesses. I will subpoena the case right now. I will subpoena the case today, contact all my witnesses to make sure everyone is available.
I have probably a 2.5 week trial scheduled to begin on August 4th,
Okay,
and he's in custody.
okay,
I've got it out of custody and during this time as well, but I can work on those.
okay. Understand, I mean, I'm putting you guys in my civil stack because this case just needs to go.
I can definitely agree with that because this case is well over 5 years old.
So, you know, between your all schedule and, you know, it's always like creating a Venn diagram when we've got everybody's schedules and we've got people in custody versus out of custody. And so the only time that I have that block is when I've given Mr. Goodwin. So I hope you can impress upon your clients that that is literally the only time that works with everybody's schedule.
I will pass it on, Your Honor. I have one more thing to raise to the court.
Hold on one second.
Of course.
Hey.
The 15th of PM, we could do reference to address any motions before the jury comes in and then.
There is a section on the 16th. Okay. Does that work for us? So we'll do a calendar call on the 8th. We can do a pre-trial conference on the 15th to deal with any final issues and then start jury selection on the 16th. Does that work?
That's
Yes, Your Honor. And my, I'm sorry. The two things. One is I forgot to mention, asked away my client's appearance today. She's at work. But two, I did speak with Ms. Renetti about having my client just be here, not a calendar call, but be here in time for trial.
Okay.
They're traveling by vehicle. She was fine with it, but she wanted some proof they were traveling. I just want to confirm on the record that they can appear by video, which is unusual calendar call as long as they're going to be here for the trial.
That's fine. Mr. Goodwin?
Yes, Your Honor. We were still waiting on a report from the expert for the state. I have not received anything yet. I believe the court was looking at a 30-day timeline, but then we had the motion to recuse. So I don't know if there's a deadline for the expert that we can rely on so that we know what we're looking at.
So, Your Honor, it's kind of a twofold thing. So the expert I retained is really just about the science behind that. There is no literature or any studies that can prove what their expert says can be proven by scientific evidence. So that's what I'm going to file a motion to strike their expert just based upon the lack of science. So there's really no report because there's just a lack of science kind of argument. But I will in the motion cite any studies that underlie my expert's opinion regarding the lack of scientific knowledge behind their expert's opinion.
Okay, so you're going to file a homework motion then?
Yes.
All right. So let's go ahead and set a briefing schedule on that. How much time do you need, Ms. Renetti?
You give me another, let's go 3 weeks. I'll have it done.
Okay. So that takes us 3 weeks, takes us to May. May 23rd for your brief to be done.
Okay.
I will then Do you want 3 weeks, Mr. Goodwin, Mr. Shetler, to file any opposition, or is 2 weeks sufficient?
Charles, 2 or 3?
You know, I have 3. I think I'm going to be in trial early June.
That's fine. So we'll go June the 13th for any opposition. Reply, I'll give you 2 weeks after that, which will take us to June the 27th.
Your Honor, and I apologize for this. Since I will be out of the country starting on June 17th to the
Okay.
28th, if I could just have a little extra time, because I just won't have any access to my emails.
That's fine. Let's go, on 17th through the 28th.
Correct.
You want 2 weeks after you get back?
Please, thank you so much.
All right, let's go July 11th. For any reply, and then let's set it for a special setting. I'm gonna be leaving the 18th through August. I come back on August the 4th, so can we do special setting July the 15th?
I'm gonna be out of, the jurisdiction. Could I attend that telephonically? or
Yes.
video?
Yes. As long as you've got a good connection.
Do you want that at 9:30?
Let's go 10 o'clock.
We're gonna call it a hallmark here.
Yeah, Hallmark hearing, July the 15th. Okay,
Thank you so much.
all
Thank you,
right.
Judge.
Anything else that we need to deal with this morning?
No, Your Honor.
All right. Thank you very much, everybody. Have a good day.
Thank you.
Thank you, Your Honor.
Okay, we're finished with all the hearings, and you see once again, there's another reset in the mix. Hopefully this time everything will work out and they will actually have these hearings on the dates that are scheduled. So we'll see if anything else pop up when we go to one of the next hearings. So I hope you enjoy all the hearings, and if so, give it a thumbs up and you'll get the next hearing soon. See ya.